Recorder has started.
Okay, Chair Schmidt, I have 532.
Yeah, Cheryl, could you read the introduction, please?
Sure. This is the Sunshine Ordinance Task Force Complaint Committee of the City and County of San Francisco. This is a remote regular meeting. Public comment call-in is 415-655-0001. The meeting ID is 2484-689-9615 ##. To enter the speaker line, press *3. It is January 17 and I have 5:32 p.m. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via WebEx and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to sotf@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, do you want to read meeting decorum?
Yes. Thank you. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. And so we can go to number 1 on the agenda.
Okay, item number 1, call to order, roll call, and agenda changes. Let's start with roll call. Member Wolf. Member Wolf not present. Member Stein.
Present.
Member Stein present. Chair Schmidt.
Present.
Chair Schmidt present. We have a quorum. I am not aware of any agenda changes. Are any of the committee members? No changes. Okay, great. No changes. Just making some notes here. Okay, are we ready to begin with item number 1A?
Yes, please.
Item number 1A, findings to allow teleconference meetings under California Government Code Section 54953, E as in Edward. The task force is expected to consider a motion setting forth findings required under Assembly Bill 361, that's AB 361, that would allow the committee to hold the meeting remotely according to the modified Brown Act teleconferencing set forth in AB 361. This is information that has to be read into the record because we did not have a task force meeting this month, which would have covered both the complaint committee and next week's upcoming EOT committee. So I wanted to let you know why that's there. We all set?
Sure. Yeah.
Okay. Item number 2, approval of the December 2022 complaint committee meeting minutes.
My apologies. I think you need to make a motion to adopt that finding.
Yeah, Cheryl, I think we need to take care of 1A with a motion, and I'll make the motion to set forth the findings required under Assembly Bill 361, which would allow our committee to hold our meeting remotely.
Okay, great. Chair Schmidt, aye.
Let's the public comment.
Let me see if I have a second. Second. I see a second. So yeah, now we can have public comment.
Yes, if there's any members of the public who would like to provide public comment on this matter, you can press *3 on your telephone to raise your hand, or otherwise use your computer to raise your hand to indicate you'd like to make public comment at this time. I'll give you a moment. I see no indications of public comment at this time.
Okay, let's have a vote.
Thanks for stepping away. I wanted to make sure I had my timer. We're just gonna have a vote, okay. Chair Schmidt,
Aye.
Chair Schmidt, aye. Member Stein,
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein to accept item A regarding findings to allow teleconference meetings. Okay, are we ready for item number 2?
Yes.
Item number 2, approval of the December 2022 Complaint Committee meeting minutes. I have a copy of the minutes. Do either of you have any suggested changes?
Not for me.
Yeah,
Go
this is
ahead, Member Stein.
Member Stein. I just saw like a couple things jumped out at me on page 7 under item 3, Petrellis comment. I just recalled that he wanted the task force to stop using WebEx for these calls was his comment, and I think it says consider not stop using WebEx in the current minutes. So it should say should consider stop using WebEx. I would just get rid of the not.
Okay.
And then page 7, item 4. Let's see, where is this? The action, I think it should just say Member Stein, seconded by Member Wolf, to find that. It says to that right now.
Say find, yes, I got that. Okay.
That's it.
Oh, that's easy to fix. Sure, I'll take care of that first thing tomorrow morning. Thank you for those suggested changes.
Sure.
We have to vote on those changes.
With those changes, I move that we approve.
I'll second.
Second. Do we have public comment?
Yes, if you'd like to make public comment at this time, you can press *3, otherwise raise your hand to indicate that you want to make public comment. Okay, I see no indication of public comment, and I'd just like to, give me one moment. We just had someone logged in as anonymous. Hello, caller. I know you just logged in. I just want to be sure if you're one of our members or not.
Hi, no, this is Michael Petrellis calling in.
No problem. Just wanted to double check. Thank you very much. I'd just like to note, we have no public comment on this item, which is item number 2, the approval of the minutes. And Cheryl, I just want to be sure you do call Member Wolf's name and mark him as absent verbally, just for the record. Thank you very much. No public comment on this matter.
Okay, so we took a vote. We have to take a vote on this item. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein to approve the changes in the December 2022 minutes.
Thank you, Cheryl. Now we can move to number 3, public comment.
Okay. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Yes, if there's any member of the public who would like to make general public comment, you can raise your hand at this time by pressing *3, or otherwise using the application to raise your hand. Okay, I will go ahead and unmute Mr. Petrellis momentarily. Whenever you're ready, Cheryl, you can make your indication.
Mr. Petrellis, you ready to begin speaking?
Yes.
Go ahead, sir.
Hello, this is Michael Petrellis speaking. I would like to again ask that the Board of Supervisors find the public funding to air the meetings of the Sunshine Ordinance Task Force, the full task force meetings. I would like for them to be aired on SF.gov TV, and I hope the supervisors with their new board president, will find the money to finally put the task force meetings on SF.gov TV. Thank you.
Thank you.
Okay, just checking to see if there's any other parties who'd like to make public comment. I see no additional parties who'd like to make public comment at this time.
Okay, so we can move on to number 4 when you're ready, Cheryl.
Yeah. Just a second, actually. Okay. Item number 4, file number 22117, complaint filed by Carnitas Bandit against the Department of Building Inspection for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and a complete manner.
Okay, I'm gonna see if the parties are here, and then I'll just tell you and others how we're gonna proceed today. First, Carnitas Bandit, would that be Mr. or Mrs., any preferred descriptor? Are you here? Is Mr. or Mrs. Bandit present today? I see that Member Wolf is here now, so we should make a record of that. I do not believe that Carnitas Bandit is at this meeting. As far as I can tell, if they do have technical difficulties, I can be sympathetic with that if they do appear later. But at this point, it does not appear that they're here to proceed. Is anyone here for the DBI, the Building Inspection Department? Okay, so no parties here.
Sorry, my apologies.
Oh, sure.
I just like to say, if you can indicate if you're a party to this matter, you can raise your hand at this time. It would be appreciated. *3 if you're on the phone, or otherwise use the application to raise your hand. If you are a participant in this item number 4, it would be appreciated. I'm not seeing any indications of hands raised right now. Oh,
Okay.
Hold on. I got it in the text. Okay, we have Patrick Hannon.
Can you hear me?
Yes, we can.
I am here for DBI. I'm the custodian of record.
All right. Thank you. Thank you. Okay, members, it looks like the petitioner is not present, and maybe we need to act as the rules would prescribe. Any motions?
This is Member Stein. I just wondered if Cheryl had gotten any confirmation one way or another from the petitioner about attending.
I didn't get any emails from, I think I got an email from Mr. Hannon last Friday, but I do not have emails from Carnitas Bandit.
And do we normally ask people to confirm that they're able to make it, or?
Well, I put it on the appearance notice. Please confirm your attendance. Not everybody does.
Okay. Sorry, I had those questions. That's it.
Okay, and having looked at the substance of the file, I'm not quite sure what we would have done with it, even if they were here, because I'm not sure how many real big questions we'd have to deal with. But since they're not here, I'd entertain a motion if anyone has one.
Do you want to entertain a motion to close the matter and give them a 60-day notice in which to contact me to let
I'll
me
make
know if
that
they want to
motion.
keep it open?
I'll make that motion.
Okay.
I'll second it. This is Member Stein.
I'd like to note that Member Wolf is now with us at 5:47 p.m.
Welcome, Member Wolf.
Okay, now that we have the motion, we can move on to public comment. If there's any members of the public who'd like to make public comment at this time, you can raise your hand by pressing *3 or otherwise using the application to raise your hand. Oh, hold on one moment. He just showed up.
Ah, okay.
Carnitas Bandit, we have called your item. Oops.
I apologize for being late. I had difficulty joining the call.
Would someone like to withdraw the motion?
Withdrawn. So we will proceed to hear the case. Let me just give people the general process here. This is our first petition that we're hearing today. We will give each of the parties a chance to speak to us, to present your case for up to 3 minutes each. After that, the members of the task force may have questions to ask of you. And after question time, there will be a period where we decide what to do with the matter. And this committee cannot make any final decisions as to the substance of a case. We may send the case on to the full task force for its hearing and its decision. We will be looking at various issues, including whether we see that public records are involved, whether we see confirmed that the task force has jurisdiction, and sometimes we'll make recommendations. With that being said, when Cheryl is ready, we have read the files, all the members. We're all here now. When Cheryl's ready, we are ready to hear from the petitioner first. Mr. Bandit.
Excuse me, Chair Schmidt, how much time is each party allotted?
3 minutes. 3 minutes, please.
3 minutes, okay. Let's see. Mr. Bandit, are you ready to begin your hearing?
Sure.
Go ahead, sir.
I apologize. It's my first time attending one of these meetings. Thank you for having me. I made a public records request for the DBI complaint servers, 4 that I know of on the property on Leavenworth. One of the owners was a member of the school board, the San Francisco Board of Education, and the complaints had actually made the paper in the Chronicle, and the person who had made those complaints actually spoke with a reporter. I find it in the public interest to know who had made those complaints and allow the public to be able to judge whether or not those complaints were made in for political purposes. I also separately had requested the correspondence with Rolla Lee, who is the reporter for the Chronicle, who had interviewed the person who had made the complaints, DBI complaints, and reviewing those results, the DBI had made available the identity of the person who had made the complaints, and voluntarily did so. to this reporter. So it is something they have done in the past. They've revealed the identity of the person who made the complaints, and I believe it's in the public interest to know who had made these complaints. Thank you.
Thank you. All right, we can hear from the respondent now.
Hang on a second.
Cheryl's ready. So you ready, Cheryl? Sounds
Yeah,
like.
just a second. I just wanted to type something.
Okay. Got it. Got it.
Mr. Hannon, are you ready to begin?
Yeah, I am.
Go ahead, sir.
Thank you, commissioners, for the opportunity to speak today and share our perspective. I'm Patrick Hannon. I'm the communications director for the Department of Building Inspection, and I'm also serve as the custodian of records, overseeing our public records and sunshine requests. In regards to what Mr. and Mrs. Bandit just spoke to, I can't speak to the purpose of why somebody would request these documents. Frankly, I don't care. We treat all public records requests the same, which is we put them into a very standard process, and we administer them using these processes to the best of our ability. We did redact the name of the complainant in this case. That ability to redact is actually authorized by the California Constitution Code, Government Code sections 6254K and 6254C. That is included in my response on page 29 of your packet. We also, in our response to Mr. Bandit, we indicated that we were going to redact, as we're authorized to do, some portions that we believe were involved to protect a person's privacy. In regards to the Bandit also says that we don't redact the name of the owner. We're not obliged to redact the name of the owner. And just because we don't redact the name of the owner doesn't automatically convey the right to know who filed the complaint. That just doesn't exist. And I assume that the Sunshine Task Force would support our desire to release as much information as possible in response to public records requests. In response to the reporter, a reporter asked me to confirm an email address, I believe. I don't believe I confirmed the person's name. The reporter said, I have somebody saying they're this person. Can you tell me that it is indeed? I said, I can't do that. He said, well, what if some version of this, well, what if we compare the email address? And that's what we did. And we're able to confirm, yes, the email address was the same. And this is based on memory. That I believe that is what happened. So to be clear, it's not like we called a reporter and said, this is the name of the person who filed the complaint. Now go write a story. Again, that's not our jam. And we didn't release that name. But I do, again, just want to wrap up by saying that we provided all the records that were requested. We provided all of the documentation that was requested, email or the complaints. We simply redacted the names of the person filing the complaint as is authorized by the California Constitution and as we informed the requester we were going to do. That's it. Thank you.
Very good. Thank you. Okay, members, any questions for the petitioner or the respondent? Yes, Member Wolf.
Yes, can you hear me okay?
Yes.
Okay, great. So some question for the respondent. Did you, besides the Sunshine Ordinance, did you check with the California Constitution and with the new Prop B privacy provisions in the city charter with regards to protecting various personal identifying information?
I referred to the good government guide provided by the city attorney's office. And then I also, Commissioner Wolf, I did go and looked at the California government code sections that were referred to in the email and that I referred to earlier to make sure that they were active.
Did the city attorney refer to Prop B at all?
I do not recollect so. But again, I referred to the good government guide. That's what I used.
I'm not sure that that's been updated for this new provision that was passed.
Perhaps not. The other thing is as part of the public information officer and the respondents to these requests, the language that we use and the citations, I believe they are something that the whole city uses. in order to make sure that the language is accurate. So this is language that, referring to the California code sections, what we put in the message to Mr. Bandit saying, we may redact some portions of this message, is very standard language that we use in a lot of these communications, and it would have been provided. It has been provided by the city overall. So it's not like something I went out there and wrote by myself, I guess is what I'm saying, Commissioner.
Thank you.
Any other questions?
Yeah, this is Member Stein. I have another question for the respondent. I'm just wondering if you can explain why you do release the property owner's names and contacts, but not a complainant's. Why, is there a privacy right in one case and not the other?
That's my understanding, is that when a person files a complaint, that there is an assumption and that the city treats it as something that is slightly more a higher standard than property information, which is actually available through other public means, right? While the owner of a property and even the property records themselves are all public information and available through public means, the actual complainant is something that is it's not sitting out there on the assessor's website. It's not sitting on our website someplace, right? It's actually a record that has been created at the request of a person in order to raise a concern about a potential code violation. And so the guidance that we've been given is that we can indeed redact that. The owner, on the other hand, like a lot of this other sort of public information that you can get from a variety of sources, is not considered to be held to that, does not have to be held to that same standard. Now, on our website, we don't include the name of the owner. But generally, when people request for the documents as part of a public records request, we will oftentimes provide it. Yeah.
Okay.
Question for first to Carnitas Bandit. Have you been able to obtain this email address in any way from which pertains to the complaining party?
I made a separate records request for the email correspondence with the reporter Roland Lee from the Chronicle, and they redacted the email address. But I do have the first name. I did see the email interaction between them, and there's a mischaracterization when I read the emails. The respondent had voluntarily given the name, but it's redacted in the records that I received.
So you saw a document that was an email from the DBI to the reporter, and there was a redaction, and by the circumstance surrounding the redaction, you believe that is an actual name that was redacted out, and that prior to redacting, that name was given over to that reporter. Is that what you're thinking?
I believe the reporter had the email. What I'm saying is they redacted the name of the respondent that they had responded to the reporter with.
Okay. So it's not the name that you're seeking of the person who complained, correct?
That they redacted that. They had responded with the name of the person who had complained. They redacted that from. They gave it to the reporter. They refused to give it to me. And when I requested records of the correspondence between the reporter, they had redacted their response from the reporter.
Okay. And at this time, you do not know the email address that could be used to make contact with the complaining party, correct?
I do not.
Okay, thank you. And to Mr. Hannon, you have not given to Carnitas Bandit the email address of the complaining party, correct?
I have not, but you know what? I want to go back and I want to acknowledge Mr. Bandit is correct. I in an email exchange with the reporter, I did provide the person's first name and last initial and their email address and phone number for one of the complaints. I believe actually that the reporter asked for another complaint, and I think that's why I'm confused, is I believe I just confirmed an address for somebody else. But indeed,
Now, yeah,
I did provide it to the reporter.
Okay, and so because you gave that name.
Oh.
Consider that should be made available to others who are seeking that information, or is there some reason why that reporter gets like unique treatment here?
No, we definitely don't want to give people unique treatment. And so if I provided this name to the reporter, then I assume that you guys would want me to provide this information to the complainant as well. And again, this was not an intentional. I think that I got my thing mixed up. So if I provide it to one, then I do want to be fair and provide it to the other. We don't usually do this. It's not what I usually do, and so that's perhaps why I'm. But if I did it, then I'm happy to provide it to Mr. Bandit as well.
Okay, and I don't think we need to have to request that you do so. I think you can see that maybe since he has requested it, he is entitled to it. So I don't know, what we're going to do with this case, but maybe if Mr. Bandit receives the same information that the reporter did, maybe the case will be handled differently by Carnitas Bandit. Who knows? Mr. Bandit, would you like to receive that information?
I would. And
okay. Okay. And so I will say,
Chair Schmidt, can I just make one other note though? Is there were multiple complaints that were filed, and this is the information. This is the name that I provided, but I don't think that I provided it for the other folks, and I wouldn't want to provide that complainant name if I haven't also given it to the reporter, because I believe I made a mistake here in giving it to the reporter, and I wouldn't want to perpetuate that mistake by giving out the name of complainants for the other complaints.
Okay, let me clarify. You will give, you're saying you're going to give Mr. Bandit the information that went to the reporter here, even though maybe you would handle this whole thing differently if another type of case came along. Is that what you're telling us?
That's exactly right. That whatever I gave to that reporter, I'll give to Mr. Bandit.
Okay.
This is not usually the way we handle it, and clearly, normally we don't give out the complainant's name even to reporters. So I'm copying that. I made an error there, but I don't want to perpetuate that error, and so I'm happy to give Mr. Bandit what I gave the reporter, but I wouldn't want to go further than that.
Great, sounds good.
Can I ask a clarifying question?
No more questions from me. Did you have something to say?
I had a clarifying question because it's not information that I know, but is Mr. Hannon, are there more than one person filing complaints on the property?
People can file, again, Mr. Bandit, I don't want to go into too much detail because what I'd say is that there were multiple complaints filed. And if there was one if they were filed by multiple people, I can provide you the name of the one that I provided to the reporter, but I wouldn't feel comfortable providing you with the additional information.
No, I understand that. What I'm trying to get clarified is because my position beyond what you shared with the reporter is that this information should be made public. So
in other words, I'm going to interject. It seems like Carnitas Bandit is seeking all identity information of all complaining parties on that property. Is that fair to say?
It is.
Okay. And so even if you do get what has been promised to you here, and there's no reason you shouldn't, I think, because we have heard that has been promised. It seems like they're not, because they didn't give these other complainants information out, they're not going to be giving you that, but you still want to seek that through your petition to the task force, correct?
Correct. And what I have hasn't at least been clear to me is if there are other petitioners. So it could be that what he's offering to give me could end this. I just don't know if there's multiple complainants. I guess
Okay.
that's my question. I don't know what I don't know.
Okay,
And,
got it.
Chair Schmidt, and that's
Yeah,
not a
yeah, go
question-
ahead.
Yeah, that's just not a question I can answer, because similarly, if I were to say no, there were no other complainants, that would confirm that this name filed multiple. Oops, did I pause? Oh, I'm sorry, I may have lost you guys. Apologies. If I were to say, can you hear me?
We can hear
Okay.
you.
If I were to say yes, there's only been one person filing, there have been multiple complaints, or yes, there's only been one person filing the complaints, that would indicate that this person, whose name I'm going to provide to Carnitas, would have filed more than one. And again, that is stepping over what I feel is appropriate for they still, even if we say, yes, this particular complaint was from this person, they still have privacy protections for those other complaints. And that the protections are from the California Constitution. So I wouldn't, and I understand Mr. Bandit's question, but I wouldn't feel comfortable even saying whether it was one or multiple complaints are filed by, this person by other people, because that in itself could potentially violate the privacy of the name that I'm going to provide.
Thank you. Got it. Okay. I don't have any other questions at this time. Member Wolf.
Yeah, question for Mr. Hannon. Do you have the policy with regards to redaction or withholding of personal information? Is this a written policy within the department, and does it get applied uniformly?
Yeah, it's not just my recollection. It's not just in our department, and there are trainings that are conducted. And that the purpose is.
I'm not talking about generalizations. I'm talking about your specific department. Do you have a written policy? And if so, was it made available for us in the record?
I mean, I don't think I provided it to you guys, Commissioner Wolf, but I do believe we have a written policy. I process multiple of these every month. Usually, you guys you don't see me a lot, so we generally try to be very responsive and inclusive, and so this isn't, this as you can tell, this is kind of a weird one, right? High profile thing, and but generally we churn through these and produce a lot of records, and don't usually have these kind of situations. I'm sorry, is that answering your question? So if we have a policy, I'm happy to pass it on to you, but basically we follow what the city tells us to follow.
I understand that, but for invoking or implementing a specific process that is part of the regular and general business of the department, especially when it's working with third parties, it has to be uniform so everybody gets treated equally. And that usually is regulated by a policy of some sort or a law. And I'm wondering if you have such a document that would have been, kind of good to know for this particular kind of case, and taking it verbally is not necessarily evidence.
I mean, we have guidelines written down, Commissioner Wolf. If you're asking me whether I have exact policies, I'd have to go back and look. I don't have them off the top of my head.
Okay, I just feel that your answers could have been a lot better, kind of iterated if the policy was in front of us, so we can actually, see it together and know for sure whether the process has been actually working appropriately or not, according to the department's policy. That's our job.
Okay, noted.
That's all I have. Thank you, Mr. Chair.
Okay, members, do we have a resolution, a motion on this as to where to go next with it?
Well, I have some questions, lingering questions with regards to what the appropriate process for this is, because Prop B, which is now in the charter, is very explicit in detail of what personal information is and how personal information is to be dealt with regards to privacy to third parties. And that includes third parties receiving permits, licenses, or other entitlements from the city, which I believe a permit would be, a building or construction permit of some sort would be. And then it goes on to say, and any persons within the regulatory authority of the city, and the Sunshine Ordinance is a regulatory, and other laws are regulatory authorities with regards to people who are filing complaints as part of that process. So I'm without seeing the department's policy, it's not clear to me as to whether there is a violation or not. I would need a little more time, go down that little bit of a shallow rabbit's hole.
Can I ask you, Member Wolf, because I'm not familiar with Prop B. So can you just be really specific about what does it say about how personal information with regards to third parties and building permits, like what
Sure.
it says?
It's a short paragraph. It's in the city charter, section 16-130. It's called the Privacy First Policy. It basically says the principles stated in subsection E, which is lower down, of this section constitutes the Privacy First Policy of the City and County of San Francisco, and are intended to provide guidance to the city when considering the adoption of privacy protective laws, regulations, policies, and practices for the city. Semicolon, the city's contractors, lessees, and grantees, semicolon, third parties receiving permits, licenses, or other entitlements from the city, semicolon, and persons, including businesses and other entities within the regulatory authority of the city. And it goes on to say that some of these are guidelines are mandated. And then it gets, from there, it goes on to more just definitions of what personal information may or may not be, and how it applies. So it's not a very long section of the law. It's only about 2.5 pages, 3 pages.
I guess I'm still not following like what the implication is for privacy there, but when was it passed?
I believe this was in 2018, November 6, 2018.
I just asked that because I, just thinking about like SFMTA, and the last time I spoke with them about revealing the identity of complainants, they reveal the identity of complainants. If you complain about your neighbor parking, in your parking thing, they will come and ticket or tow, and they will absolutely reveal the identity of the complainant. And so I'm just trying to figure out what is the city policy, and is it left to each individual? Is that what Prop B kind of says, that the different departments set the policy?
This is a citywide guideline. This is for all policies with regards to it. And it does say in certain sections that some of these guidelines are mandated, and that the Board of Supervisors can actually implement very more detail within these guidelines in that way, shape, or form. I don't think they have, but nonetheless, this creates some uniformity across the board. So that's why I asked for their policy, because it would have been good to measure it against this privacy policy to determine whether they acted appropriately in not revealing the complainant, or whether it was inappropriate, with regards to Sunshine. Now, Sunshine is disclosure, and Prop B is not disclosure. So I think that's kind of where I'm sitting with this at this time. So I would think that it's worthwhile for the task force to debate it, and maybe we can get a little legal advice on it, because it is possible, could be an edge issue. Don't know. Law enforcement has edge issues that we know about that involve non-disclosure, which are contained in other areas of law. So I'd be open to moving this forward to the task force.
Is that a motion?
Yeah, I was gonna say.
If we're ready for one, then I'll make it. I find that this complaint and sorry, I'm looking for the complaint number. Is
22117.
22117 is within the jurisdiction of the Sunshine Ordinance Task Force. And the records are public, and forwarding it for hearing to the full Sunshine Ordinance Task Force.
I can second that. This is Member Stein.
Okay, there being a motion, if there's any members of the public who would like to make public comment on this matter, you can do so at this time by raising your hand using *3 if you're on the telephone, or otherwise using your application to raise your hand. I see no indications of request for public comment at this time.
Okay, Mr. Chair, I would just also like to request that the respondent provide the department's policy. And they have both parties have a period of time to submit further records for the full hearing, but I think it would be a good idea at this point, since that's pretty much the crux of this case, this complaint.
Sure. Yeah, let's, can we get any kind of written policy you have on this, Mr. Hannon?
Sure.
Okay. Could you send that over to Cheryl Leger and also make sure that when this goes before the full task force, that it is included in what you submit?
Yes.
Okay, thank you. So I think we're ready for a vote.
Member Wolf.
Aye.
Member Wolf, aye. Member Stein.
Aye.
Member Stein, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Moved by Member Wolf, seconded by Member Stein, to find that this complaint, 22117, is within the task force jurisdiction. The records are public, and recommend forwarding to the task force for hearing.
We are forwarding it.
Yeah.
We're not just recommending, but that's fine. Yeah.
Did we want to include that request for a period of time in the motion? I was so curious about that.
Request for a period of time.
To provide a written policy.
I would suggest that it be included in the minutes.
All right.
Just for clarification that the committee is requesting a copy of that policy.
Yeah. Okay. Chair Schmidt, are you ready to go on to item number 5?
Yes, please.
Item number 5, file number 22131. Complaint filed by Michael Petrellis against Supervisor Gordon Marr, Board of Supervisors, for allegedly violating Administrative Code Section 67.29-5 by failing to respond to a request for Proposition D calendar in a timely and or complete manner.
Okay, Mr. Petrellis, you're present, correct?
Yes, I'm here.
Great. Okay, is anyone here on behalf of Supervisor Gordon Marr?
Give me one moment. I am just checking. While I'm checking, if you are part of this matter, if you can raise your hand using the application, it would be appreciated.
Okay, so yeah, if someone does come along, we'll give them a chance, but let's go ahead and hear from Mr. Petrellis about this case. When Cheryl's ready, we'll give you up to 3 minutes.
Okay.
Mr. Petrellis, you ready?
Yes, I am.
Go ahead, sir.
Hi, this is Michael Petrellis. I submitted a request to Supervisor Gordon Marr for his Prop G calendar, and it looks like he responded on the same day that I sent it. I submitted the request a little bit after midnight on October 15, and then later that Saturday at 3:17 p.m., he confirmed receipt of the request. And I thought that was terrific news, and that it would equal receiving his calendar. Long story short, I've never received his calendar, and he's now out of office, so I think my complaint has evolved. There's still the matter of where is his calendar and how can I obtain it, and that leads to the part that's evolved. And the question is, what happens to a supervisor's records when they leave office? That's it. That's what I want to say.
All right, thank you. Anyone, last call, anyone here on behalf of Supervisor Gordon Marr? Okay, not being so, we have non-appearance. Members, any questions for Mr. Petrellis? Yes, Member Wolf.
Actually, it's not a question for Mr. Petrellis, but kind of a question of clarification as to what is the procedure in the at the Board of Supervisors for retaining records of just former elected officials, specifically supervisors. Does the clerk become the custodian at this point? Where do those records go? Since it's mostly an electronic calendar, is that something that Department of Technology retains? You know, I think those questions are really before us since there's no respondent to answer.
This is Mr. Petrellis. I'm hoping that either this committee or the full task force can get some answers from the appropriate people at City Hall about where do the records go when an official is either termed out of office, not elected, or in a case where they're not an elected official but still a city employee. What happens to their records when they leave?
Well, it looks like
This is Victor Young.
oh yeah,
I don't want to speak on behalf of the clerk of the board or their operations, but I believe they do maintain those records. But my suggestion is to write those questions and submit them to the operations deputy director, who should be able to respond to those questions with more with a more specific answer.
Wait, sorry, Victor, who did you say should be contacted?
It would be the deputy director of operations for the board of supervisors, clerk of the board's office.
Who is that?
That would be Wilson Ing.
Oh, okay.
I do believe his division handles former supervisors' records, but I don't know how they do it or what the procedure is. I believe that Member Wolf would like to speak.
oh yeah, go ahead.
Yeah, I would say besides trying to figure out what the issue is or even trying to repair the issue, I think the complaint does survive. And I think the question would be just on the face of it, the complaint wasn't responded to in a timely fashion or at all. And there was time, at least 2 months prior to this complaint being submitted, I believe. No? This is complaint submitted. November 4th. So yes, there was about almost 2 full months for the outgoing supervisor to comply. So I would just move this along, and if it gets resolved in the meantime, and the complainant, petitioner, Mr. Petrellis, feels that he's satisfied, then it's his choice. He can withdraw it.
This is Member Stein. I think to me, it's a very clear-cut case, and the type of case that probably should go to a consent calendar, with a recommendation of a finding of violation 67.295. It was, right, which is what was being requested, for failing to respond to a Prop G calendar request, and failure to send a representative to the hearing, 67.21E. And I would feel comfortable sending that to a consent calendar if we also included a recommendation that compliance and amendments follow up with by contacting the Deputy Director of Operations for the Board of Supervisors about clarifying where records go when a supervisor leaves, and helping to facilitate obtaining those records if they're there. So if there's any support for that, I would make a motion.
Yeah, I'll second it. Yeah. Go ahead.
Okay, so the motion is to,
This is Victor Young, and I just have one worry in that the respondent may not have been properly notified, as if they're out of office, they would not be responding to the email address we have on file for them.
Yeah, but they would have received the complaint prior to their leaving office. Is not that right?
Yes, but making a ruling without the party present, I defer to your judgment, but they may not have been notified of this actual meeting, since they don't have access to that email address anymore. But I defer to your judgment on that.
does the Board of Supervisors keep a up-to-date contact information for former board members?
I would have to defer to Mr. Ng on that.
I feel like I still would send this, because we're not making the decision, we're just sending it to a SOTF consent calendar where they will make the decision. But in the meantime, we can also reach out to the Board of Supervisors or the Deputy Director, whoever, to try to make sure that we have the most current contact information for the former supervisor. If people are amenable to that.
I think we have Member Wolf seconded the motion. Thank you. Thank you, Mr. Young. I think that we're not quite sure, how to deal with Supervisor Marr, but I think we still should, for purposes of today, we should be sending this on to the task force. So let's maybe get public comment on this.
So if there are any members of the public who would like to make public comment at this time, you can press *3 on your telephone to indicate to raise your hand, or you can indicate through the application raising your hand to indicate that you would like to make public comment. I don't see any indications for public comment at this time.
Okay, let's vote.
Just a second. Member Stein.
Aye.
Member Stein, aye. Member Wolf.
Aye.
Member Wolf, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Member Wolf, to send this matter to the next consent calendar with a violation of 67.29-5 for failing to respond to a Prop G calendar request, and 6721E for failing to attend the hearing, and the need to contact the deputy director of operations. That's what I was trying to get and do.
Recommendation that a compliance and amendments contact the Deputy Director of Operations for the Board of Supervisors, Wilson Ng, about where records go when a supervisor leaves.
Hang on. All right.
And to obtain the most current contact information for the former supervisor to make sure they're notified of the full task force when it's scheduled for the full task force.
Okay, so let me read this as I got it, because I'm not sure it's complete. Send the matter to the consent calendar for a violation of 67.29-5 for failing to respond to a Prop G calendar, 67.21E for failing to attend the hearing, and forward the matter to the Compliance and Amendments Committee to research.
To follow up
By
contacting Deputy Director of Operations.
To follow up about records go when a supervisor leaves, and to obtain the most current contact information of that member of the Board of Supervisors. And
To make sure they're properly notified for the.
Can I clarify? You're saying that we send it to the consent calendar for the full task force, but then do you want compliance and amendments to do anything before that decision is made, or do you want to simply say that after the task force looks at it, that compliance and amendments would then do that?
I mean, ideally, I guess it would happen in advance. That we need them to contact the Deputy Director of Operations, find out what's supposed to happen with those records, and to get the most current contact information so that we can notify the former supervisor. So I guess that is not something that's part of the recommendation to the full task force. That's, I guess, what I'm recommending should happen now. Or it could be that we as the complaint committee do it.
look, with this notice of a consent calendar, I can contact Wilson tomorrow when we get to work to find out what actually happens to these records.
Well, if you can do that, all the better.
Yeah, and then we can put it on a consent calendar, I think, for February 1st. Or is that too soon?
Okay.
That's my thought.
Okay, yeah, I think that's actually better. So Cheryl, if you can contact the deputy director, 2 questions for them. What happens to these records when 3 questions. What happens to these records when a supervisor leaves? Can we obtain the records? And can we obtain the most current contact information from the former supervisor?
That's current contact information of that. So what happens to records when a supervisor leaves? Number 1, can we obtain the records?
Mhm.
And can we obtain the most current contact information of that departing supervisor?
Yes.
This was Victor Young again. I'd just like to say, in regards to the consent agenda date of scheduling, I would like to defer that to Chair Yankee to determine which meeting to place that on. And just because our next meeting in February is very packed, and he may not want to put it on that agenda.
Sure.
All right, well, okay. But I've got this information. The least I can do is follow up on what we need. And that I'll do tomorrow morning, if Wilson's
you.
available to talk to me.
Yeah. Thank you so much.
Yeah, I will. So about this motion here, I want to make sure we've got it right. 6721E, failing to attend the hearing and refer the matter. Sorry,
No, since you're going to handle that part of contacting the director, you can just leave the motion at
they're failing to attend the hearing.
6729-5 and 67.21E, and you read it correctly both times already. So
Okay. Okay. All right. Got it.
Got that? Okay. And Cheryl, when you're ready, we can go to number 6.
We didn't have public comment, correct? We had no public comment?
We already voted.
Yes.
Yeah, so
Yeah,
that's
we're all
number 5 is done.
Sorry, I don't mean to sound like I'm not paying attention here.
All right. No problem.
Three things right now. Okay, so we're ready for item 6?
Yeah, could you read it, please?
Yeah, sure. Item number 6, file number 22130, complaint filed by Michael Petrellis against Supervisor Catherine. What? Okay.
Oh, sorry. Hi, this is Dominica Don.
Hello?
Hi, this is Dominica Donovan here on behalf of Supervisor Stephanie.
Okay, can I finish reading the summary?
Thank you.
Sorry.
Yeah.
Sorry about that.
Yeah. Complaint filed by Michael Petrellis against Supervisor Catherine Stephanie, Board of Supervisors, for allegedly violating Administrative Code Section 6729-5 by failing to respond to a request for Proposition D calendar in a timely and or complete manner.
Okay, the one thing I want to do up front here is it appears that we may have a potential consent calendar matter here because there is an admission in the record. They're apparently not contesting. And so I'm not even sure if we need to hear from the parties. But I want to leave that to the members. It looks like Supervisor Stephanie's office has admitted to a violation, and so I don't know if there's going to be any substantive dispute here. Members, any thoughts on that? You want to hear it, or should we just send it to consent?
I mean, this is Member Stein. I was going to suggest this is very appropriate for a consent calendar since there was an acknowledgement of non-compliance. That it should go to consent for 67.295. But if the parties are here and they want to say something, I don't think I would, want to stop them. But I do agree that this is a matter for the consent calendar.
Okay, and I would agree. Just before Member Wolf has something to say also, I do want to ask, am I correct? I'm going to ask the respondent that you are not contesting the finding of violation in this case.
No contest. We failed to ask for additional time and
Okay,
acknowledge that the request was voluminous. So no
Okay.
contest on our end. Thank you.
Okay, I'm gonna then, thank you. Member Wolf, go ahead.
I'm just wondering where in the record does it show that they have declared no contest?
I don't remember the page, but they included in their response.
189, 190,
190.
189, 190, I believe.
Okay. I mean, did they fill out one of our forms? Because if they did, then it really didn't need to come here.
I believe I did fill out a form and submit it.
Yeah, okay. Is that usually, helps to, kind of defer things out of committee when there's a signed a consent of non-compliance or no contest. It just would automatically go to consent calendar.
I think I'm gonna go ahead. Member Stein wanted to know if the parties have anything to add, but it appears that this is something that should be sent for a expedited hearing on a consent calendar to the full task force. But before we make that motion, Mr. Petrels, do you have anything to add?
Yes.
Let me say when Cheryl's ready, you can go ahead and make a statement, and then we'll also allow respondent to make any statement they wish to make.
Thank you.
Chair Schmidt, are we timing this?
Yes.
Okay.
Up to 3 minutes.
Yeah. Mr. Petrellis, are you ready?
Yes, I am.
Go ahead, sir.
Hi, this is Michael Petrellis. I want to give the context here. I submitted a request to all of the supervisors for their Prop G calendars because we have this great law that requires them to maintain their calendars, and I wanted to see how the supervisors would respond, if they would respond, and then what they would send me. And as you know from previous complaints, there's been some interesting responses about some of the supervisors thought I was asking for calendars related to ballot Prop G that was before the voters this past November. So that's one thing I want you to know. Why I was requesting these calendars had very much to do with seeing about compliance from the board because, they're our legislators. The second thing I want to say is I'm looking at Prop G, Section 67.29-5. And in the first paragraph, the last sentence, I think, is really crucial for all supervisors and their staffs to be aware of. It says that such calendars shall be public records and shall be available to any requester 3 business days subsequent to the calendar entry date. So there's a quick turnaround required in the law, and I think the supervisors and staffs should be aware of that.
All right. Thank you. And now we'll give an opportunity for the respondent to say anything you want to say to us in the circumstances. When Cheryl's ready.
Ma'am, can you give me your name, please?
Dominica Donovan.
You ready to begin?
Yes, I just have no contest. Nothing more to add.
All right. Thank you. Okay, members. Do we have a motion? I mean, you can ask questions if you wish, but otherwise, I would encourage I don't know if we have any issues left in this thing.
This is Member Stein. I can make a motion to send this complaint to SOTF's consent calendar with the recommendation to find a violation of 67.29-5.
Second.
Okay, there being a motion, if there's any members of the public who would like to make public comment at this time, you can raise your hand by pressing *3, or otherwise using the application to raise your hand. I'll give everyone a moment to raise their hand if they so wish. I'm not seeing any indications of raised hands at this time, so I believe we can close public comment.
Okay, we can vote on this one.
Hang on a second. Okay, Member Stein?
Aye.
Member Stein, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Member Wolf, to send this complaint to the consent calendar and find a violation of 67.29-5. Which means are we ready for the next item, Chair Schmidt?
Yes, we are.
Thank you. Bye-bye.
Thank you.
Mr. Trellis. Item number 7, file number 22146, complaint filed by Maria Schulman against the Department of Animal Care and Control for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely and or complete manner.
All right.
I was just wondering if Justin Alberto, are you a representative on this matter?
Yes, I am.
Okay, and I'm unmuting the complainant at this time.
Okay, so we can hear first from Ms. Schulman. The petitioner, go ahead. You can make a statement to us up to 3 minutes when Cheryl's ready with the timer.
I am ready. Ms. Schulman, are you ready to begin speaking?
Yes, I am.
Go ahead.
So basically, I believe that the respondent is withholding records and inappropriately citing attorney-client privilege in order to justify that withholding. The respondent had previously stated that they invoked the rule of reason after consultation with the city attorney's office, but according to 6721I, all communications with the city attorney's office with regard to this ordinance shall be public records. The respondent also appears to have discussed their use of the rule of reason with a third party, Mr. David Steinberg at the Department of Public Works. And I think it may be the case that by just sharing whatever input the respondent received from the city attorney's office with this third party, the respondent has waived their attorney-client privilege. Also, leaving aside the attorney-client privilege issue, in response to a different records request, Mr. Steinberg provided me with a document that the respondent had not provided for this request. So I'm missing at least one document from the respondent. And also the respondent did not provide the email exchange that I included on page, I think it's page 11 of the handout. And so that's another record that the respondent could have provided and didn't. In conclusion, I think that the respondent is in violation of section 6721I and also that they're inappropriately withholding records. Thank you.
Chair Schmidt, I believe that Ms. Schuman has finished her comments.
I'm sorry, I was muted. Yeah, we can hear next from the respondent.
Okay, just a second.
Cheryl's ready. Yeah.
Okay. Justine Alberto, ma'am, you're the woman speaking?
Correct, yes. Hi, good evening.
Okay, are you ready to begin?
Yes.
Go ahead.
Good evening, members of the Sunshine Task Force Complaint Committee. My name is Justine Alberta. I'm the custodian of records at San Francisco Animal Care and Control. In regards to complaint 22146, which is also Ms. Schulman's next request, 22715 request, which we received on 12/23. The request was an immediate disclosure regarding all records pertaining to the decision to invoke the rule of reason. So it's in regarding to make the decision to invoke. I just want to state that. Schulman asked our department to prioritize this request over all other requests. The request was completed on 12/27. We prioritized this request before her other 21 requests that were open. ACC responded to the request on the next business day, which was Tuesday, 12/27. That was after the weekend and 12/25 Christmas holiday. We provided 2 documents, the Good Government Guide and a meeting invite. We stated that all records regarding our decision to invoke the rule of reason had been released to Ms. Schulman on the Next Request platform. Some records were redacted on the basis of information security, and other records were withheld on the basis of attorney-client privilege. The Court of Appeals has recognized the importance of attorney-client privilege in protecting the confidentiality of written communications between the City Attorney's Office and other city agencies. Those communications are not subject to disclosure under St. Croix versus the Superior Court case from 2014. We have provided all appropriate documents to Ms. Schulman regarding this complaint and this records request. Thank you.
All right, thank you. Next, members, any questions for the parties? I'm not seeing any questions. I have one question, which is for the respondent. There's some reference to a concern about information security. Is that in reference to data that's contained in the Zoom notices, or is there something else that refers to?
It was in reference to the meeting invite, so it's the data for the logins to the meeting.
Okay, thank you. Thank you.
I have a question.
Yeah.
Also for the respondent, what is the circumstances that you invoke the rule of reason?
As of right now, I believe we have 21 open requests from Ms. Schulman. So because all of her requests are voluminous, we had to prioritize her request, and we're responding to them in the order that they're received, in addition to, unless she tells us that she'd like us to prioritize them.
So you're not complying with the ordinance?
We are complying. We are providing the documents on a rolling basis because they are voluminous.
And
but for this part,
are these immediate disclosure requests?
Correct. Okay. For this particular request, because she had asked us to prioritize it, we did complete it by the next business day.
So I'm not following why you're invoking the rule of reason.
So the request itself, this particular complaint, is asking us for documentation as to why we invoked the rule of reason, right? So she's asking for all of our documentation and communications on why we invoke the rule of reason. It's not in regards to invoking the rule of reason for this particular complaint. Does that clarify? Okay, thank you.
Yes, it does. She's asking for your reasons for invoking the rule of reason.
Correct.
You're not invoking the rule of reason here in this hearing.
Not in this instance, correct.
Okay, I understand. All right, thank you.
So just to the respondent, just to clarify, it seems like the only documents that are were not produced that would be responsive here or redacted, that information was withheld either on this information security basis or on the attorney-client privilege basis. Am I correct?
I'm sorry, Chair, was that for a question for me?
Yeah, for you. The only withholding here was on this information and security and attorney-client privilege bases, correct?
Correct. So Ms. Shulman in her opening statement had said that we didn't provide some documents which she had provided to the complaint committee. However, the documents she provided aren't pertaining to the decision to invoke the rule of reason. They're documents which stated that we had invoked the rule of reason. So I want to state that that's why it wasn't included in this particular response.
Okay, thank you. Yeah. Any other questions for the parties, members?
So I have a question for Ms. Shulman, a petitioner. So I'm sorry, your complaint is on their not providing the information because on them not providing the information of why they invoked the rule of reason. Is that correct?
Ms. Shulman, you're muted. It looks like
Sorry, yeah, I was
go.
muted. Yeah, they're not providing all the records that I asked for. They invoke the rule of reason. Well, they say, I don't know what that means, but they sent me an email in August of 2022 saying that they were invoking the rule of reason. And so I made this records request in December asking for all their records that pertain to the decision to invoke the rule of reason against me. And I do not believe that they've provided all the records.
What records do you think are still outstanding?
So first of all, Miss Alberto provided like a calendar invite, but then if you look at page 13, that record was not provided by Miss Alberto. That was provided by DPW, where David Steinberg accepted this calendar invite. This calendar invite, the date for it is Thursday, December 6, 2022. That's after they invoked the rule of reason. So I'm not sure. I'll be transparent with you. I don't know what this meeting was really about. Presumably, they discussed the decision to invoke the rule of reason against me in this meeting. I don't know why, but yeah, I think there's more that's missing. And I think that because Miss Alberto discussed apparently her decision to invoke the rule of reason against me with Mr. Steinberg in this meeting, she's waived her attorney-client privilege.
Well, maybe.
Mm-hmm.
Maybe. I mean, they both work for the city, and if it's within the confines of the city, I'm no attorney, but attorney-client privilege is generally to what other parties that are not party to the issue. But the question becomes is attorney-client privilege applies if they're being represented. Mr. Steinberg's not an attorney; he's a public information officer. So I don't really. That's just my own edification, and to the committee members here, I don't know how attorney-client privilege plays into this. With that response.
Yeah, I think that if there is a communication with council and there's more than one city employee involved in that conference, I don't see that there would be a waiver myself. I think it would have to be to get to a waiver here. You'd have to have somebody who's not under the city umbrella, who is either in the conference or they get subsequent disclosure. So your reading, Member Wolf, is generally the same as my understanding.
Yeah. Okay. So that's the first point. The second point. Well, I guess I'll wait until we're ready to do to make a motion. I don't have any other questions for either party at this time.
I think we're done with questions on this. So go ahead.
Yeah, I would say, generally the rule of reason is invoked for a single request that is voluminous, not that there are multiple requests or multiple work tasks, whether it's from one person or from 37 other people. That it can't invoke a rule of reason based upon unrelated requests. Now, if these were all requests, if there was one request and then there was a follow-up question to that same request, and it kept compounding, that's maybe that could be maybe, but the rule of reason is more like, I would like every single email that was ever, sent and received for the last, 3 years. That could be considered burdensome and would be a good rule of reason. That was the purpose of invoking that. But just because one person has submitted, 2 or more requests and they're unrelated, I'm not quite sure that really rises to a reason. Rule of reason to me, I think, is a confounded argument and defense. I think it's very difficult. I think we have to hold a high bar to it to really determine whether there's truly a hardship and a burden to that. I'll stop there.
I would generally concur with that, Member Wolf. I believe that my take on this matter is twofold. One is that I don't think technically we're looking at the substance of a rule of reason invocation in this matter, because what the request was for was information about the rule of reason being invoked elsewhere. And so it was that information that Ms. Shulman says was not fully provided. And so I believe that the exemption, the privilege that is at issue in this particular file number is attorney-client privilege. that now with going back to rule of reason, yeah, the rule of reason is, in my opinion, way overused. And I think that it is completely misunderstood. It's a doctrine that I believe it's kind of a messy doctrine, and I don't think that people should be using the rule of reason without understanding better what it's supposed to be about. But that's not really what this case is. Now, one thing that I will add on the attorney-client privilege issue is I will just tell the petitioner that the respondent cites to the St. Croix case. And the St. Croix case was a holding that says that the charter, to some extent, overrides the Sunshine Ordinance, where the Sunshine Ordinance says that the privilege is limited. And so I believe that St. Croix comes into play here with regards to the privilege issue. And so generally, even though the Sunshine Ordinance says something about privilege, I don't think anyone would say you can't read that without also knowing what's in this St. Croix decision. That's I think, and that could be something that would be talked about if we send this on to the full task force.
Yeah, Mr. Chair, I just interrupt for a second. I don't think this rises to the St. Croix at all, because St. Croix was looking for the complainant there was looking for communications between Mr. St. Croix and the city attorney, and that was the kind of I think the crux of that particular case. I don't think that is involved here at all. I don't know that a request was made, with regards to that. This has to do with voluminous requests and other things that seems to me.
Well, I disagree. I think that this file number is strictly about the request by Ms. Shulman to understand why the rule of reason had been invoked on other items. And so she's looking for the sort of the let's call it the various communications and documents that may have led up to that invocation on her other requests. And so they gave her certain information, but they withheld other information based on attorney-client privilege.
Yeah,
and she contests whether that invocation is proper.
Yeah. Yeah, I have trouble with this one.
I'm not sure if we necessarily need to even sort of make a final call on that, because I think we could probably make a motion. Again, to the parties, we can't make any final decisions here, but we're looking at this to see if we should have it heard before the full task force or if something else should happen with it.
Yeah, I have a question, Mr. Chair, for you as also being a practicing attorney, and our attorney here is a member. The records that have been withheld that are held based on attorney-client privilege, do they have to be keyed? Do they have to be noted? Can you just say that these records, that, quote unquote, any such records, it could be all records. I mean, if you can't, how do you identify whether a record is attorney-client privilege or not? Is it just communications with your attorney? Is that what they're talking about? I mean, I think those questions need to be answered also.
Yeah, well, the generally, I'll just make a general statement that this privilege is the privilege that governs written and oral communications with legal counsel. That's the privilege that we're talking about here. And I don't think that it's defined in city law in any way. It really is the privilege that is it's a California level definition.
Yeah, got it. Because
It
it's
is,
law.
it's hard to really give you much more than that without really getting into a lot of detail.
Yeah, okay.
But I think it is, in this situation, as in others, it's the communications privilege, and it is the privilege that is discussed in many decisions, but St. Croix is one of those decisions.
Yeah, I hear you. I'll withhold my further questions on this until if it gets heard by the task force. We don't need to discuss it here.
Okay. I'm going to make a motion that we have jurisdiction. These are public documents, and so we make those determinations, and we forward this matter for hearing and decision by the full task force.
Second.
So we can go to public comment.
Yes, there's only one other person in the meeting with us. Mr. Steinberg, would you like to make any public comment on this matter? And you can raise your hand if you'd like to. I don't see any indication of public comment at this time. I believe we can move on.
Okay, let's vote.
Chair Schmidt,
Aye.
Chair Schmidt, aye. Member Wolf,
Aye.
Member Wolf, aye. Member Stein,
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Wolf. To find that there is jurisdiction, the records are public, and forward this matter to the task force for decision and hearing.
Great, thank you. We have one more petition.
Item number 8, file number 22147. Complaint filed by Maria Schulman against David Steinberg and Public Works for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and or complete manner.
All right, the parties being present, let's, when Cheryl's ready, we can hear from Ms. Schulman first. Up to 3 minutes.
Ms. Schulman, are you ready?
Yes, I am.
Myself ready? Okay. There you go.
Okay, so the respondent initially failed to provide a reason for not treating my request as an immediate disclosure request. When pressed, the respondent said that my request did not meet IDR standards because it did not have the words immediate disclosure request written on the envelope, subject line, or cover sheet. However, Next Request does not provide users with an envelope or subject line or covered sheet. The respondent seems to be claiming that there is some kind of header that Next Request users can fill in, but that is inaccurate. All that Next Request allows is for you to write immediate disclosure request in the body of what you're asking for, and that's what I did. Then there was this whole thing where I attempted to submit a second IDR request to the respondent by email, and I got an automated message saying that my email had been blocked by the respondent. The respondent claims that I'm mischaracterizing the nature of what happened there. However, I am merely quoting verbatim the automated message that I received. It said, quote, "Your message to David Steinberg has been blocked." It doesn't really matter about the email. That's not really why I'm here. I'm here because I believe that the respondent inappropriately downgraded my request from an IDR to a standard request, and because I believe that the respondent is still inappropriately withholding records on the basis of attorney-client privilege when that privilege had already been waived. Additionally, the respondent claims that they needed to consult with another department in order to fulfill my request to search their own email account, and that therefore my request was not simple, routine, or readily answerable. I think that the respondent needlessly complicated their own protocol for responding to records requests, and given the scant number of records that I ultimately received, I don't see why an outside consultation was necessary. Thank you so much.
Thank you. All right, when Cheryl's ready, we can hear from Mr. Steinberg.
Mr. Steinberg, are you ready?
I am ready.
Go ahead.
Good evening, Chair Schmidt, members of the committee. Public Work acknowledges that the department is subject to the Sunshine Ordinance and that the requested records are public. My response to the complaint, which I submitted, covers the department's position. However, I do want to ask explicitly that the committee find that the complaint has no merit and recommend no violation of the full task force. Public Works cannot be found in violation of 6725 because the request as submitted was not a proper IDR, as we explained in our response. Although this was not a proper IDR, we were extremely prompt in our response and release of records. All of this was done long before the 10 days of receiving the request. I'm happy to answer any questions you have, or I can respond to some of the statements that the inaccuracies that she just said, but all of that is actually in my submitted written response. So I will leave it up to you to ask if you so desire. Thank you.
Thank you. All right, members, any questions for the parties? Yeah, Member Wolf.
Okay, for Ms. Schulman, can you please explain how you interpret the respondent to have waived attorney-client privilege?
I think, let's see. So, I just think, I mean, and maybe I'm wrong, but I think that because Mr. Steinberg was in a meeting with Miss Alberto, and it didn't seem like there were any attorneys present in the meeting, that's not attorney-client privilege. Maybe they were discussing something that the city attorney had said, but I don't think it falls under attorney-client privilege. And just for the same reasons that the same argument that I tried to make in the prior complaint that you guys just heard.
Okay, thank you. And my second question for Mr. Steinberg, are you aware of the primary form that comes up for next request?
Yes.
And can you tell me if there is a subject line there?
There is not.
And so if there's no place to put in the words IDR, because there's no place to put a subject line. How should we think about that with regards to 6725 and its requirements?
As I told Ms. Schulman, she says that the guidance from the city attorney is that the words immediate disclosure request must appear across the top of the request and on the envelope, subject line, or cover sheet. All she had to do was put it as the first line of her request, and you would have seen it. So what happens is someone submits a request. I get an email saying, hey, there's a request. Well, you can see a preview of the message. One of the main reasons for having to put it at the top, not a subject line, not on the envelope, because there's no envelope on next request. If you put it at the top, someone getting an email can see a preview, and if it says immediate disclosure request, you can jump on it and you're not going to miss it. However, what she did was she put it as the second paragraph of her request. She didn't put it across the top as required by the ordinance. That's why it didn't meet. That's one of the reasons it didn't meet the requirements of an IDR.
So you're claiming that just because it was placed somewhere in the middle of the document and not placed across the top of the request?
Absolutely. So the attorney says it's not just a technicality. It's to ensure that IDRs are seen, they're prioritized, and they can be acted on immediately. She didn't follow the rules.
And had she or anyone else put the words immediate disclosure request across the top of the body of the next request form, you would have accepted that as an IDR?
I'll split that question. If someone puts it at the top as the first line of their request in next request, then I'm assuming it's an IDR, and that's how I get dozens of them, and that's how I respond to them. However, as I noted in my response, generally, we don't consider any request that's asking for emails or especially chats to fall under the requirements of an IDR, because they can't. It's not like, can I please see a copy of the minutes from last month? Here, they're in the file cabinet or they're on the drive. I have to go and ask my IT team to run a search. They're not simple, routine, or otherwise readily answerable. Okay. That being said, my IT team actually worked really fast on this one, and I was able to get her the email, responsive emails the next day, and then it took a little bit longer to get the chats from Teams, because that has to be, they have to run a different search, and I have to load it through Outlook in a different way.
Okay, and my last question is: you said you received guidance from the city attorney, and you were very explicit on, on the guidance that you received regarding the immediate disclosure request. Was that done in writing or was it verbally?
That's written guidance from the city attorney. I sent her a link to it. It is from, I have it here. It is from a letter or an opinion from the city attorney. Sorry, I gotta find my browser here. That says, let's see. It was a memorandum to the mayor, the board of soups, and the Sunshine Task Force, among others, November 16th, 2021. Page 4 says, immediate disclosure request, the ordinance requires a fast response, et cetera, et cetera, et cetera. There are two requirements for a public records request to be a valid IDR. First, the words immediate disclosure request must appear across the top of the request and on the envelope, subject line, or cover sheet transmitting the request, et cetera, et cetera, et cetera. Second, the purpose of the IDR is to expedite city's response to simple, routine, or otherwise readily answerable.
Okay, I got the rest of it. Okay, yeah. So that's a memo from the city attorney. It's not their written opinion. Or else it would have probably said opinion.
Sorry, yes, you're right. It was a memorandum to that, and I sent her a link to that.
Yeah, okay, very good. That's all I have. Thank you, Mr. Chair.
Yeah, I Myself, I don't think I have any questions on this one. No, nothing. I think it's pretty straightforward. So if we don't have any more questions, does anyone want to move this forward? Anyone want to make a motion on this? I will note, it does seem like there's no question that the requirement is the language of 6725 placed across the top of the request. And so, we can look at the request and we can make a sort of a factual decision. Do you think that wording is placed at the top of the request? And if it's not, it seems like it wouldn't qualify under 25. This is something that, we can look at when we make a final decision. Of course, we're only in a committee here, so we don't make any final decisions.
Well, I'll make a motion to find that the information and the records are public. It's within jurisdiction of the task force, and for the task force to deliberate this and make a determination as to whether it is merits compliance or non-compliance.
This is Member Stein. I was going to say, I'm not sure what exactly we're deliberating, in the sense that, I know there's this question of whether or not it's an IDR in spirit or reality, but it's still, the request got answered in one day and on a rolling basis, in the manner of an IDR, even if Mr. Steinberg from Public Works is saying that it could easily have been missed as an IDR because it wouldn't have shown up just kind of visibly, in a piece of email that might have been in his inbox. But it still seems like this request got answered as in the manner in which we expect, using the protocol of an IDR, even though, they're denying that they had to treat it as an IDR. So I'm just not sure what there is to debate.
Well, to me, the debate is what we deal with quite often is that respondents tend to convert IDRs into regular requests, and then the enjoyment of the provisions of 6725 are lost, and that also affects timeliness. I think that's the crux, just reading on page 753 of Ms. Schulman's complaint here. She did.
But that being said, the response came in one day and the rest of the response came 3 days later. So it really did follow the protocol of an IDR, whether or not Mr. Steinberg recognized it as such.
Mm-hmm. I understand.
It seems to me like, this, I can see if you were to open it and read the request, it has IDR, right? He says in the second paragraph, really it's the second sentence. it's right up there. There's hardly anything to the request, and IDR does kind of jump out at you, but that's only if you open it. And so if you're just scanning your email and your email is just showing you a little bit of text, or, that comes at the beginning of whatever the message is, I do see how you can miss it. But since it was responded to exactly as one would want an IDR to be responded to me, it just doesn't seem like that there's much there.
I'll say I tend to be in agreement with both of you. And yet I think that ultimately I may agree with Member Stein that I don't necessarily see a violation. I think but I'm not in deciding mode as I sit here today. I do think that based on what Member Wolf's motion says, I think people may have differing thoughts on the substance of this. And so I think regardless, it should be sent forward. So I'm going to second Member Wolf's motion. But I don't want to stop if you guys want to talk further about it. Any other thoughts before we?
Yeah, the only other thought I have is that the original, I can't seem to find the original request. I see the thread of the next request, but I don't even see the original request in there. I see a request was made, a request was received on December 28th, 2023. I'm looking on page 783, and it's corroborated. Both parties sent in the same documentation. I don't even see any. I see the discussion about it, but I don't.
Mr. Schmidt, I can help you here if you want.
Sure.
If you go to page 756.
756.
It shows the top of the request. So it says request 127192, the date received, the requester, the request. There's those two sentences, two paragraphs, two sentences.
Oh, is that all it is?
That's it.
It's just two sentences?
That's it.
Because she put, this is an immediate disclosure request, in the second sentence, you're declaring this as not being an IDR?
Correct. It does not meet the requirements of an immediate disclosure request.
Okay.
Because it's not at the top of the request.
Okay. Thank you very much.
Yeah.
I'm ready for a vote.
Public comment.
I'd like to make a comment.
I think we're moving this case forward. I would say, there's issues that we can't resolve here, Ms. Shulman. So, just for purposes of efficiency, I'm gonna go ahead and have a vote here.
If there is any member of the public who'd like to make public comment, you can raise your hand at this time by pressing *3. We only have one other person with us today. I don't see any indications of requests for public comment at this time.
Okay.
We can close public comment.
Yeah, we can. When Cheryl's ready, we can vote on this.
Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Member Wolf, seconded by Chair Schmidt, that the information and records are public, there is jurisdiction, and forward the matter to the task force to make a determination if it merits compliance or non-compliance.
Okay, good. Thank you to the parties this case will go forward now. And that's what we're here to decide. Okay. When you're ready, Cheryl, we can call the next item.
Hang on a second. Item number 9, announcements, comments, questions, and future agenda items by members of the complaint committee. Anybody got any ideas?
Nothing from me. Looks like we don't have anything that we need to add in today.
Okay. All right, ready for the next item, Chair Schmidt?
Yes.
Item number 10, adjournment. I have 7:38.
Move to adjourn.
Second.
Second.
Thank you, members. We are all done.
Thanks, Cheryl.
Thank you all.
Bye.
See you guys.